the next case to come before the court is State of Ohio versus William Roberts. All right, each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. How much time do you want?
5 minutes about me, please.
You may. We have read your briefs and we are ready to proceed when you are.
Thank you, Your Honor. Your Police Cycle Court Counsel. My name is Attorney Thomas Ryan, and I represent the defendant appellant William C. Roberts. Again, I'd like to reserve 5 minutes for rebuttal. So, I raised 3 assignments of error on Mr. Roberts' behalf, pursuant to a plea bargain between Mr. Roberts and the State of Ohio. He entered pleas of guilty to several counts. That would be 2 counts. One would be kidnapping with a sexual violent predator specification, felony of the 1st degree, carrying a penalty of 10 years, mandatory penalty of 10 years to life. The other count he entered a plea of guilty to was rape with a sexual violent predator specification, also carrying a mandatory penalty of 10 years to life. Court of Appeals went through Mr. Roberts' criminal rule 11 rights with him at the time of the plea, informed him of the penalties of the counts, informed him of the maximum fines, informed him of the sexual registration requirements, informed him of mandatory post-release control up to 5 years. Unfortunately, at no time did the trial court ever inform him that the maximum penalty was 20 years to life if it were to impose a consecutive sentence. Additionally, the trial court at no time, at the time of the plea or at the time of the sentencing, nor did any of the attorneys ever raise the issue of allied offenses. At the time of the sentencing, assistant prosecutor spoke, defense counsel spoke, the court imposed a consecutive sentence of 20 years to life in addition to the sexual registration requirements and mandatory post-release of 5 years. I'm asking the Honorable Court to vacate the plea and to make a finding that the plea was not knowingly, intentionally, and voluntarily made because the trial court failed to comply with Criminal Rule 11 in terms of not letting the defendant appellant know the maximum penalties, which would be 20 years to life. Additionally, at no time did the trial court or the prosecutor or defense counsel ever address the issue of allied offenses. Trial court didn't do it at the time of sentencing. Trial court didn't do it in its sentencing journal entry. I know the State of Ohio, I'm very familiar with the case from 1988, State versus Johnson, but the assignment of error would have been basically out the window had the trial court just said, look, you understand I can impose a consecutive sentence of 20 years to life. Again, we have somebody who is a defendant, somebody who is not an attorney, somebody who is not a judge. Why can't we just have, in this age of transparency, let them know? Maximum penalty is 20 years to life. I'm not sure what I'm going to do yet, but I can, maximum penalty, the maximum sentence is 20 years to life if I should seek to run those sentences consecutively. It was not done. Now, I understand State v. Johnson. I understand State v. Bishop. I understand all the cases. I've read a ton of cases on this. Unfortunately, intertwined and intermingled with the fact that the trial court or any party failed or did not mention the allied offenses issue, I submit that the plea is not knowingly, intelligently, and voluntarily made. Under State v. Johnson, the 2010 Ohio Supreme Court case, and obviously this court, I think this court is held, the Ohio Supreme Court is held, this court at this time is supposed to conduct as to whether or not the plea was knowingly, intelligently, and voluntarily made, and whether a proper allied offenses of similar import analysis was done. This court is constrained with and supposed to use a de novo review. So State versus Johnson, 2010, the Ohio Supreme Court indicated a factual inquiry must be made prior to sentencing as to other allied offenses of similar import. However, none was done. It was not mentioned at the plea, it was not done in the sentencing, it was not done in the trial court's sentencing journal entry. In no time did the trial court inquire, no time did the state of Ohio put forth that they were allied offenses of similar import. Again, we have a rape count, we have a kidnapping count. Do we know the specifics of the kidnapping count based upon the indictment or the bill of particulars? We don't, it's generic. And I do some federal work as well. When you have a federal indictment, it's laid out specifically as to what the allegations are in the indictment. It wasn't done here, nor did the trial court ever inquire, nor did the trial court say, well, gentlemen, are these allied offenses of similar import? It wasn't done.
Counsel, what effect, if any, does it have on the fact that defense counsel did not raise the issue at sentencing?
Defense counsel didn't raise it either. Defense counsel didn't raise it either. I'm not sure.
What's the effect of that?
Well, here, so ultimately, Mr. Roberts got a 20 to life sentence. He got a consecutive sentence. What effect did it have? I didn't raise ineffective assistance to counsel. I don't know. I mean, maybe strategically he shouldn't have. Maybe strategically he should have. I don't know. I don't know. I mean, he argued for a concurrent sentence of 10 to life. He argued for it, but he didn't mention it. The bottom line is he didn't mention it, nor did the state of Ohio, nor did the court. Under Johnson, under Rogers, the Ohio Supreme Court indicates that it has to be done, it must be done. And we know, Davey Logan, we know that a lot of times rape and kidnappings merge. It just wasn't done. There was no analysis done, nothing. And the trial court said, here, if the trial court had done two things, wouldn't be here right now. Number one, maximum penalty is 20 to life. Also, is there an agreement as to whether or not these are allied offenses? Or the trial court could have said at the time of sentencing or in its journal entry, I find that these are not allied offenses of similar import, therefore a consecutive sentence is justified. Now, assignment of error number 3, the consecutive sentence. Court did make findings. Court did make findings in open court at the sentencing hearing and in the journal entry. I raised that because of the fact of the allied offenses and knowingly to preserve my client's record to raise all the proper assignments of error. I think that.
Can I go back a second? Something you just said. You said that the court could have said, I get the first part, but I find that these are not allied offenses of similar import.
Correct.
And therefore consecutive sentences are necessary. That's kind of a hybrid of two separate things, isn't it?
Okay,
It's kind of what the prosecutor did at sentencing.
It kind of is. I'm kind of intermingling the two. I know they're separate issues, but the bottom line is trial court at no time at the plea or the sentencing ever mentioned the phrase or terminology as required to do under Ohio Revised Code 2941.25 of that allied offense of similar import analysis. Columbus has spoken on this. Ohio Supreme Court has spoken on this. It says and mandates that a factual inquiry must be made prior to sentencing. Well, here it wasn't done at all. It wasn't done. So I submit here the plea is improper, the sentencing is improper. I ask this honorable court to find that the plea was not knowingly, intelligently, and voluntarily made, and to remand it to the trial court for further proceedings. I'll reserve the rest of my time if the court has no further thank you. Or questions.
Good morning, Your Honors. May it please the Court, I'm Vince Colucci with the Medina County Prosecutor's Office for the appellee in the state of Ohio. I will start with the first assignment of error, which is that the plea wasn't knowing, intelligent, voluntary because of the maximum penalties issue under Criminal Rule 11. Roberts, of course, acknowledges that the court correctly informed him of the maximum on each count of rape and kidnapping, which was 10 years to life in prison. But he then, without any authority, claims that the trial court had to advise him of the possibility of consecutive sentences, which could result in 20 years to life, which of course we know is what he ultimately got. Mr. Rye mentions the Johnson case, which is directly on point, directly addresses this issue. They held in that case that the failure to inform a defendant who pleads guilty of more than one offense that the court may order him to serve any sentences imposed consecutively rather than concurrently is not a violation of Criminal Rule 11 and does not render the plea involuntary. So that's pretty much settles that. The court even explained that the maximum penalty language from Criminal Rule 11 refers to the maximum penalty for a single crime, not for the total of all sentences. So it's absolutely not a requirement at all that he be advised that he could have been facing a total if it was consecutive of 20 to life. I'll move to the merger issue. That was not raised below, so it's plain error. And I thought Roberts was acknowledging that in his brief. This is not a de novo review at all. This is plain error. If it's raised below, it is de novo review, but it was not raised below in this case at all. So we're talking about, was it plain error for the court not to conduct a merger analysis? And the Supreme Court of Ohio has held clearly that it is only plain error for the court not to conduct, for a trial court not to conduct a merger analysis if the defendant demonstrates a reasonable probability that his convictions were for allied offenses. So it's the defendant's burden in that case. And Roberts cannot make that showing. You'll see that at sentencing, the assistant prosecutor actually sets out the facts of this case in some detail. And it took quite a bit of time to explain why Roberts' actions with the kidnapping and the rape were different actions with separate and identifiable harms. So the state did mention this issue. I disagree with that statement.
She didn't mention it in the context of allied offenses, though. It seemed like there was kind of like maybe one sentence and then the rest kind of went to the consecutive argument.
The state never said the word merger, and it never said the word allied offenses when talking about the facts of this case, but talked very clearly. It did mention about the consecutive sentences. You're right, and that's. But the test in terms of the separate and identifiable harms is the exact test for merger and whether these should be allied offenses, and that's what the state was addressing at length. And I've quoted the entire what was stated about the facts that happened here. But essentially, the victim was lured into Roberts' car by deception and picked up from school and then taken to another location where the rape occurred. And certainly gets into a little bit more detail than that, but we don't have the benefit of a full trial here, obviously. We just have what's stated at sentencing about the facts. And Roberts and his attorney did certainly argue against consecutive sentences, but they did not dispute any of the facts that the prosecutor set up about this case. They didn't dispute the idea that the rape and the kidnapping charges were based on different actions that resulted in different harms. None of that was disputed by the defense at the sentencing hearing. In terms of whether merger had to be addressed, there's no law that says, or no case law or anything that says that the trial courts have to just sua sponte raise merger to do an analysis in every case. There's not a whole lot of law out there about that, but the 8th District, for example, has a pretty clear, actually I'm not even sure this is clear, but they say trial courts only need to do a merger analysis when multiple charges facially present a question of merger. So then, of course, what facially presents a question of merger is a good question in just about every case, but I would submit that there was not a facial question of merger in this case because this is the exact kind of situation where courts in Ohio have found consistently that a defendant can be convicted of both kidnapping and rape. I cite many cases in my brief, but I'll focus on a few of them here from the Supreme Court and from this court. The Ware case, the Supreme Court of Ohio held the defendant could be convicted on both of these counts because he lured the victim to his home by deception before then later raping her. In the Craig case, Supreme Court of Ohio again holds that the defendant can be convicted of both rape and kidnapping. The defendant abducts the victim while she's walking home, takes her to a nearby apartment, where he rapes her, convicted of both. The same thing was held by the Supreme Court of Ohio in the Hill case, the Powell case that I cite. I would focus on the Winchester case out of this court, which is similar to this case. 2013 case, 2013 Ohio 4683. There it was held that the defendant could be convicted of both kidnapping and rape, where the conduct of forcing the victim into a car was separate from the conduct that was the rape. There was a restraint that was prolonged, a substantial movement, so that the kidnapping has an independent significance. That goes back to the Logan case from the 70s, Supreme Court of Ohio case. There were two other cases from this court that I cited, Person and Evans, where kidnapping and rape was found that it should not merge. There's also other cases from other districts, the 2nd District, the 7th, the 10th districts, all finding, cite cases finding that the kidnappings and rapes charges should not merge. In terms of the consecutive sentences, there are, of course, statutory findings that need to be made to impose consecutive sentences. Those were, all I can say there is that the court did make the appropriate findings, both on the record and in the journal entry. In both places, the trial court actually made findings under two different sections, 2914 C4B and C4C. Although the court actually only needed to make a finding under one of those sections, the court made a finding under both of those subsections. And essentially recited the language of those sections verbatim. So I don't know how the court could have complied any more with the requirements on consecutive sentences. But I think the merger issue here is really the main issue I think that's being raised, but I think there's a lot of case law out there that says that this was not a facial issue of merger. Especially where the defendant doesn't raise it, doesn't dispute the facts that the state sets out in detail at the sentencing hearing, talking about why there are separate and identifiable harms, and that's the test. So, was there anything? I would ask that this court affirm the judgment of the trial court. Thank you.
I don't remember how much time you wanted for rebuttal, but you have a full 5 minutes.
Thank you so much. I think I could do without these glasses anymore. Reading too much. So, this is the Williams Court, it says, the Ohio Supreme Court. An appellate court should apply a de novo standard of review and reviewing a court's revised code 2941.25 merger determination. Court below employed that standard. Since the state, and here's what I said, I'm going to read it from my brief. Since the state demands reversal based upon only its assertion that the court below should have applied abuse discretion review, we affirm the judgment of the Court of Appeals, which used the de novo review standard. So the prosecutors cited State versus Logan, which talks about merger and rape and kidnapping as to the allied offenses. Here's the problem: we don't know under count one. We don't know because count one states unlawfully and purposely did by force, threat, or deception removed Jane Doe 1 from the place where Jane Doe 1 was found, or restrained the liberty of Jane Doe 1 to hinder, impede, or obstruct. So, is the kidnapping the fact that he took her from school, or is the kidnapping part of the animus that occurred during the rape? We don't know, because there was no allied offenses determination by the trial court. The trial court could have easily said, even when talking about the consecutive sentence, I find consecutive sentences are appropriate under 29-29-14. Additionally, I find that the defendant removed the victim from the school for purposes separate and aside from the rape. Didn't do that. It just wasn't done. So we have a due process argument, we have a notice argument. It's just not right. It just wasn't done at all. It wasn't done at all. And also, at the time of the plea, prosecutor outlined, plea bargain outlined the maximum penalties, but the prosecutor at no time at the time of the plea indicated we're going to be seeking a sentence, maximum sentence of 20 to life. So I submit this is improper, it's wrong, it wasn't proper notice, it wasn't done. Trial court failed both of the plea and the sentencing to make any sort of allied offenses of similar import analysis at all, which it was required to do. Again, I'm asking tribal court to vacate the conviction, the sentence, and send it back for further proceedings. Thank you so much, Your Honor.
All right, thank you. All right, thank both of you for your presentations. The court will take the matter under advisement and will issue a written decision in due course, which will be mailed to both sides as well as posted on our website, and that